want to start off by reiterating just sort of a quick overview of current state of encryption law in the United States. If the law were not the way that it is, we wouldn't have the freedom to encrypt that we currently enjoy in the United States today, if the law as it is now didn't give US tech companies the freedom to encrypt that they do. We wouldn't be having this debate. We wouldn't have the iPhone, iMessage, WhatsApp, et cetera, that we have right now. So currently, it's possible to say pretty strongly that strong encryption, by which I mean encryption that has not been intentionally weakened at the behest of a government, is legal in the United States for now. That's thanks to some law and policy decisions that were made back in the 1990s that have renewed relevance today. The 1990s gave us several laws relevant to today's encryption debate that I'm going to talk about. First up is the Communications Assistance for Law Enforcement Act of 1994, or CALEA for short. It was passed back in 1994, a quarter century ago, because even back then, law enforcement was concerned that they were, and they used this phrase back then as well as now, going dark due to the advent of digital telephony and the internet, and that basically the burgeoning options for communications beyond just traditional telephone lines would allow criminals to cloak their activities beyond the ability of law enforcement to detect them. So what CALEA does in response to those concerns is that it mandates wiretapability for phone networks. Certain regulated entities, which are covered telecommunications carriers, as well as any new communication services that the FCC, the Federal Communications Commission, deems to be substantial replacements for traditional local phone services. Now, thanks to FCC rulemakings since 1994, that includes both two-way interconnected VoIP calls as well as broadband internet. Those are both things that the FCC said, well, those are enough. They function sufficiently like traditional phone, that those are also subject to CALEA's mandates. However, CALEA has some important limitations built into it. One of them is that the government is not allowed to dictate how covered entities, such as telco carriers, design their systems and their networks, their equipment, to comply with this overall goal of being wiretappable for law enforcement. This provides a lot of predictability and flexibility for covered companies in that they know what the objectives, what the requirements are, but they have the freedom to make their own designs and to innovate within that framework in order to make progress in their own technological sector. There are also some important compromises in CALEA that have become more important in recent years I'm going to talk about. One of them is the information services carve-out. CALEA expressly does not cover so-called information services, which basically means the internet. It was still very much in its infancy back in the early 90s, and having this carve-out was deemed to be important to allow the United States tech sector and the internet sector to flourish. So now websites, social media, chat apps, email, etc., they're all free to design however they want to. They do not have to be wiretappable for law enforcement because they are not covered by CALEA. Another carve-out is what I'll call the encryption carve-out, which says that even covered entities, so telecommunications carriers, for example, are free to encrypt people's phone calls and throw out the keys to decrypt them. They only have to decrypt calls for law enforcement if they both provided the encryption and possess the information necessary to decrypt. So if they encrypt a call and throw away the key, they are under no mandate to be able to decrypt for law enforcement. Additionally, if there's some other over-the-top encryption service that's being used to encrypt a phone call and the telecommunications carrier, for example, wasn't the one that provided the encryption, it stands to reason it would be impossible for them to be able to decrypt it anyway. They are not mandated to do that. So these two carve-outs, along with the flexibility around not being able to dictate from the government how to design their systems to comply. These were all compromises that were reached in the 90s because of a number of different stakeholders being in the room when this statute was being hashed out between not just law enforcement interests, but also civil liberties groups, privacy experts, information security experts, all of whom pushed for these limitations. And this is how it all shook out. So the upshot, the bottom line, is that CALEA does not require Apple, Facebook, WhatsApp, Signal, et cetera, to build in exceptional access for law enforcement to be able to decrypt people's communications or allow law enforcement to listen in response to demands from the Attorney General, the FBI, et cetera. And the government is not allowed to restrain the innovation of secure technologies under CALEA. If things had been otherwise, if CALEA had required those things back in 1994, we wouldn't be having the conversation, the debate around encryption that we are having today. This is the whole reason that we have encrypted phones, encrypted voice calls, end-to-end encrypted chat apps. It's all because CALEA left internet companies and even telecommunications carriers free to design encryption that even they couldn't decrypt, and free to innovate to improve their security over time. Now, originally back in the 90s, it wasn't really that big a deal that we had these two carve-outs that I discussed, because encryption was not really in widespread consumer use. The programs needed to encrypt your email or your phone calls or what have you were really clunky. They were not user-friendly. They were hard to use. Most people did not bother. Now, in 2020, for the last few years, encryption is in much more ubiquitous consumer use because it's built in by default to popular devices such as your iPhone and popular chat apps such as WhatsApp. This raises issues for law enforcement because now that more people are using it, that means that more communications and more devices that previously would have been accessible to law enforcement are now harder to access. But nevertheless, it's important to remember that what law enforcement likes to call warrant-proof encryption, and which I just call strong encryption, is exactly what United States law allows, despite the sorts of calls and pejorative claims that you hear from the Attorney General and people who should know better, that Apple, Facebook, et cetera, are acting above the law or creating lawless spaces. That's not true, that they're doing exactly what the law allows them to do. I want to check if there are any questions so far about CALEA. Kristen, I'm going to look to you to just sort of give me a thumbs up or a thumbs down. So thumbs up, no questions so far.
I don't see any questions.
Great.
So far.
Okay, wonderful. All right. So that's CALEA, but CALEA, as I mentioned, is mostly about regulating phone carriers. It doesn't impose mandates on the actual mobile devices that we use. So what about device encryption? What's the law there? There is no express law compelling a company to decrypt data that it doesn't hold that is stored on an end user's device, your phone. It used to be that the Department of Justice and the FBI were using search warrants in conjunction with orders under a 1789 statute called the All Writs Act, or AWA for short. I've put up some of the text of the AWA here. Basically, it's intended as kind of a gap filler statute for effectuating an existing order of a judge. So if you need some other order to carry out, give effect to a search warrant, you can issue an order under the All Writs Act as a court. And so that's what the DOJ was using up until about late 2015 to issue orders directed at Apple or directed at Google saying, we have a search warrant for such and such phone. It's a Google Android device, it's an iPhone. Here's an AWA order saying that you have to unlock this phone in order to carry out that search warrant. Because it used to be, prior to about late 2014, early 2015, that Google and Apple had the capability to unlock locked devices for law enforcement to extract data from them. They re-engineered their mobile operating systems after about that time so that they were no longer able to do so. So both the law and the technology have evolved since then. But up until late 2015, courts had been signing these AWA orders for the government, for law enforcement, without any real analysis. And this happened dozens of times. And Google and Apple weren't really bothering to challenge them up until around October of 2015, like right when I started my job here. There was a federal magistrate judge in Brooklyn who finally said, hey, Apple, I have this request from the government to issue an AWA order to unlock a phone. Do you think the law actually requires you to do that? And Apple sort of thought about it and came back and said, no, we don't think it does. And the court agreed and said, look, CALEA established this comprehensive statutory scheme. It was an express choice by Congress not to place a duty on Apple to do anything with regard to decryption here. And CALEA trumps the AWA. The AWA is intended just as this gap filler statute where there isn't any other governing authority. Here, CALEA squarely is the governing authority, and it chose not to place any sort of burden on Apple. The government appealed that decision by the judge, but then the defendant whose phone it was magically remembered his passcode, and then the government dropped the appeal. So we didn't necessarily get a chance to see from an appeals court or any other higher court whether that low, trial court level judge's decision was correct on the law. We also didn't get an answer out of the better known Apple versus FBI case, which is the case out of San Bernardino from around the same time. The Brooklyn judge's decision came out less than 2 weeks after the original order in the San Bernardino case, where in mid-February, the San Bernardino court had ordered Apple to design a custom version of iOS that rolled back multiple security protections that Apple had built into iOS that could then be installed on the San Bernardino shooter's phone so that law enforcement could brute force guess his passcode to the phone. But you'll remember that CALEA prohibits the government from requiring even CALEA-covered entities to adopt any specific design for complying with the law. And that's assuming that Apple is even covered by CALEA, which it's not in this context in terms of devices. So even if CALEA did cover Apple in that context, CALEA expressly prohibits exactly what that order would have done, which is to say, here's exactly the steps that you need to follow in order to carry out this goal of ours. CALEA expressly prohibits that. So at the end of February of 2016, when the Brooklyn judge issued his opinion, he was signaling very clearly in the direction of this court, who was having its original order challenged by Apple to say, we don't have to comply with this. But we didn't see a decision on the merits because on the eve of the court hearing at which the court in Riverside, California, near San Bernardino would have considered the parties' arguments, the government suddenly moved to drop the case because they had bought an exploit to hack into the shooter's phone from an unknown third party for what later turned out to be somewhere around 900,000 taxpayer dollars. So if you fast forward to today, between early 2016 and now, 4 years later, a lot of the debate around encryption in the United States had mostly been concerned with devices rather than communications encryption, end-to-end encryption for communications. That has swung around mostly to focusing on messaging services. The one exception to that is that a few months ago when that member of the Saudi military shot up a naval base in Pensacola, that shooter also had a couple of iPhones that the government wasn't able to get into and were loudly making demands for Apple to assist. If there is a rematch over between the FBI and Apple over those phones, we don't know about necessarily yet. And even if there is a court order telling Apple to unlock them, it might be technically impossible for Apple to comply. Because as I mentioned, in recent years, Apple has repeatedly re-engineered the mobile OS for its phones to make it harder and harder for Apple to decrypt data on devices, because Apple, is part of what I would say is kind of a trend of companies recognizing that they can position themselves as being part of somebody's threat model for who they don't want to get their hands on that person's information, which is understandable in light of several years of what's now called the techlash. After enough privacy gaffes by enough big tech companies, they start saying, look, you know what? In order to respect your privacy, we're going to make it harder and harder for us ourselves to be able to see that data of yours. And that can be good from a consumer standpoint to the degree that it might limit it might provide some reassurances that big tech companies in the Bay Area aren't going to be able to snoop on all of your communications and all of your data. But on the other hand, it has this impact on law enforcement's ability to investigate now as well, because they are no longer as able to get assistance from those same tech companies. And that's what caused a lot of this, a lot of the tension and friction right now. So that's the law around encrypted devices. What's the law about encrypted messaging? So chat apps, such as WhatsApp, count as information services under CALEA, meaning they don't have to follow CALEA the way that a traditional telco carrier like Sprint or T-Mobile or whoever has to do. One of the lessons that I think the DOJ learned after the San Bernardino case was that if they are going to file these going dark type cases to try and compel tech companies to assist in access to encrypted data, they need to be doing that under seal instead of in the public eye. It was kind of a rare and unusual move for the government to file that San Bernardino attempt to compel Apple's assistance in public, in open court. It seems to me that they were counting on public opinion falling their way in light of what was at the time the worst terrorist attack on US soil since 9/11. And it seems like they got kind of caught by surprise when public opinion was divided and really kind of came out the other way, where people said, oh, that's my phone. I don't want you being able to get into my phone. And so lesson learned, file these cases under seal. Thanks to intrepid reporting by Reuters journalists, we learned in the summer of 2018 that the government had tried to compel Facebook to change the encryption for voice calls over Messenger. So Facebook Messenger allows end-to-end encrypting, texting and voice calls, although not by default. End-to-end encryption, to back up for a second, means that only the parties to a conversation are able to read or hear what's being said. The provider of the app, such as Facebook in this case, cannot decrypt that information, can't make sense of it. Anybody who attempts to intercept that communication will just see encrypted gobbledygook. So that's what end-to-end encryption means when you hear that about. This will come up later when I'm talking about Zoom. So as said, the government was trying to wiretap some suspects in a gang investigation in California's Central Valley out in Fresno. So they went to court, allegedly, according to these Reuters reports, to try and force Facebook to change the encryption so that the government could listen in on these messenger voice calls. Everything that we know about this case, what little we know about these case, comes from leaks to the press. Everything about this case is still under seal. But from what we can tell from these reports from Reuters, the government tried to compel Facebook to change Messenger's encryption. The government denied, the court denied the government's motion. But we don't know a lot of details. We don't know what the government's legal argument was. We don't know what the court's reasoning was in siding with Facebook over the government. We don't know what laws were invoked. Did the court interpret CALEA? Was the court interpreting the All Writs Act? Was the case only about the federal law around wiretapping, the Wiretap Act? We have no idea. We can infer that those press reports are correct and that Facebook prevailed in this case because that was in 2018, and then in early 2019, a little over a year ago, Facebook announced that it planned to upgrade the encryption for all of its messaging services to be end-to-end encrypted by default. So that is not just Messenger, but also WhatsApp and also Instagram direct messages. And it seems like if they had lost that fight in court and had been compelled to change their encryption for law enforcement, it seems unlikely that they would be announcing this design change. At least that's my read on it. And Facebook's announcement seems to be a main reason that the debate in the United States swung from its prior focus on law enforcement access to encrypted devices to being a lot of focus on end-to-end encrypted chat apps instead. As a kind of a footnote, I'm one of the people who, along with ACLU and the Electronic Frontier Foundation, brought a case in court here in the Central California Court in Fresno to try and ask the court to unseal the sealed opinion that it had issued in that Facebook Messenger case. The court denied our request. We appealed, we took that up to the Ninth Circuit. We just had oral argument in that case a couple of weeks ago. The stream is available on YouTube. I didn't get to go into the courtroom and sit there. I had to watch my colleague while sitting here at home in my living room, watch her argue from her living room to the Ninth Circuit Court of Appeals, who were all sitting in their living rooms, which was a little anticlimactic. But we're waiting for a decision on that. And based on the panel's questions to counsel on both sides during oral argument, I'm pretty optimistic that the Ninth Circuit will rule in favor of greater transparency, greater access to court records, and will order the court in Fresno to unseal at least a redacted version of its opinion explaining why it rejected the government's attempt to compel Facebook to make those changes to Messenger. A lot of my work at CIS at Stanford has been around trying to improve access to court records, and that's something that is have obvious import to members of the press as well. So I'm optimistic that we'll get a ruling that will not just help me, but hopefully it will help all of you as well. So moving along, if there's any questions so far, is that a question? No, okay.
Not seeing any raised hands at this time.
Okay, great. So in summary, what we can infer from that Brooklyn judge's decision, from the San Bernardino case kind of fizzling out, from this sealed Facebook case that we don't know much about, we can infer that under current US law, encrypted smartphones, encrypted messaging services, those cannot be forced to change their encryption designs in order to allow law enforcement access to people's devices or to people's messages. And that kind of certainty in the law, we don't totally necessarily know. Those are all, those are all district court decisions, all three of those, at least, even the Ninth Circuit case that we have right now is only about the right to access court records. It's not about the underlying merits of the case, of the government's request there. So the fact that this seems to be the state of the law based on our understanding of the statutes on the books of these courts' interpretations. And so that means that if you are Facebook, for example, you can then go and announce this ambitious change to your messaging platforms and act in reliance on that. All other companies can act on reliance on this being the state of the law around how CALEA should be interpreted, what technical assistance companies can be forced to provide to law enforcement when it comes to encrypted data. And one of the benefits of companies like Facebook and Apple sitting on gigantic piles of money is that they have the deep pockets to test the law when it comes up in these sorts of cases and to push back, which is something that hopefully redounds to the benefit of smaller actors as well that also provide encrypted services such as Signal, which has a very small number of employees compared to someplace like WhatsApp. While that is the current state of the law, where we have very strong freedom to encrypt for companies, even for CALEA-covered companies, it's something that some senators are trying to change. There's a new bill called the Earn It Act that it has about 10 co-sponsors right now, including Lindsey Graham and Richard Blumenthal. Stands for Eliminating Abusive and Rampant Neglect of Interactive Technologies, which doesn't even make sense grammatically. Like, I hate it when there's these back-derived bill names where you just start with the word you want, because it's always a painful exercise, and here it doesn't even make any sense. But I digress. So what this bill would do, this was introduced in the Senate Judiciary Committee a couple of months ago, is it would curtail immunity for child sexual exploitation material, or CSEM, on online platforms under Section 230 of the Communications Decency Act of 1996. This is another creature of the 1990s. Congress was really interested back in the mid and late 90s in passing laws around the internet, and they actually made a lot of good choices back then that are sort of bearing fruit today. The law was passed in 1996. It says that online platforms can't be held liable for what their users say and do on the service, with certain exceptions, such as for federal intellectual property law and federal criminal law. So as an example, if you defame me on Twitter, I can sue you, but I can't sue Twitter. If I commit a state law crime on Twitter, such as cyberbullying, criminal harassment, something that is a crime under state law but not federal law, same thing. The state attorney general could prosecute me for that, but can't go after Twitter. This bill would change that with respect only to child sexual exploitation material, which means not just imagery, but also stuff like grooming children to be abused, enticing children to be abused using an online platform. The bill seems to have been partially inspired by Facebook's announcement last year about encrypting all of their services in conjunction with a New York Times story last fall about this kind of material being on platforms, especially Facebook. So the bill seems targeted at social media platforms, which is the context where a lot of the discussion around Section 230 has focused when Section 230 has become kind of a flashpoint in recent years as part of the techlash. But it's important to remember that Section 230 doesn't just apply to social media companies. It would apply to all websites that allow users to post or share or store their own content. So that means messaging apps, email, cloud storage. It means if you have if your news outlet has a website that allows users to post comments on news stories, it means that that protects your news outlet from being held liable if somebody says something crappy in the comments, as they invariably do. So those are, remember, these entities that are given this immunity under Section 230 are the exact information services that CALEA leaves free to design their encryption however they want. So you can see how there's kind of an inherent tension between those two things. Now, the Earn It bill is not on its face about encryption at all. It's about establishing a commission that would come up with a set of best practices for companies to adhere to as a safe harbor in order to retain their immunity under Section 230. The objective of those best practices under the bill is to combat child sex exploitation material on these services through various means. But encryption is the elephant in the room around this issue. It's easy to foresee, for reasons that I'll get into, that those best practices would condemn any encryption designs that don't have an access mechanism for law enforcement built in. So this bill kind of stands as a message to Facebook and other entities that do allow end-to-end encryption, which is you need to allow law enforcement a way to see the content of those encrypted chats, or you need to be prepared to pay through the nose by being exposed to what could be significant legal liability from civil lawsuits and under state law. That's a different approach from what the FBI and the DOJ were doing before, where their focus was kind of more on devices, as said, and more on trying to use different legal mechanisms. Now there seems to be a recognition that because current law does not require any sort of assistance to, sidestep encryption for law enforcement access, that means that DOJ has to pursue a new law. And this particular bill, by focusing on curtailing Section 230 immunity, builds on the passage of the Sesta-Fosta law that you may recall from 2018, which carved out a Section 230 exception to immunity with regard to sex trafficking. But that bill got rid of the immunity under Section 230 full stop. There was no option to be able to keep it. Here, the Earn It bill allows providers to keep their immunity under Section 230, contingent upon jumping through certain hoops, such as complying with these best practices. So to dig into it more, and I want to apologize for how text dense I know a lot of these slides are. This is a really, really long bill. I've tried to sort of summarize some of the key points here. One important thing to remember that I often see misstated in blog posts and other coverage about this bill is that it would only take away Section 230 immunity with regard to child sexual exploitation material. It would not curtail it more broadly for other claims, such as defamation, as the example that I gave earlier. There's a broad range of online service providers, interactive computer service providers in the language of 230 that would be covered. Arguably, the bill would not reach devices, but when I've talked to people about this bill, they have argued that there might be a clever way to reach those devices indirectly, because if you're Apple or Google, you provide interactive computer services like chat or a website or a social media platform, whatever, but they also are the providers of Android and iPhone. And so there might be an argument that because they provide encrypted devices as one part of their business, that could potentially provide grounds, depending on what these best practices look like, for curtailing their Section 230 immunity in this other part of their business that involves interactive computer services. The way that the bill sets up this jump through hoops mechanism for retaining immunity, it allows entities to retain their Section 230 immunity by earning it by complying with one of two safe harbors. The way to guarantee retaining Section 230 immunity would be for the entity to certify compliance with a set of best practices for preventing online child sexual exploitation, which would be developed by a 19-member commission headed by the Attorney General, which would then be passed on by the AG to Congress for approval. An officer of the company, so of Facebook, of Apple, whoever, would have to certify that the company was complying with those best practices. If there were knowing false statements in that certification, then the officer who signed it could go to prison for up to 2 years or face a fine. The other option, if a company does not want to or can't certify that it complies with those best practices, is for the company to implement other so-called reasonable measures with respect to that goal of preventing child sexual exploitation, fighting it on their service. But this isn't an immunity guarantee, and so that's not much of an immunity. The whole point of Section 230 has been to cut off exposure to lawsuits and prevent companies that are covered by Section 230 from having to go through a long, protracted litigation fight in the first place. So it's not a lot of a safe harbor if you still have to litigate the question of whether you deserve to be immune. And so this is kind of the you pays your money, you takes your chances option. You could say, here are the measures that we have decided are reasonable for fighting CSAM on our services, but then you're going to have to go to court and see whether the court thinks that what you've done is reasonable or not. One of the other things that the Earn It bill does is that it lowers the mental state required for providers to be held liable for CSAM on their services from having actual knowledge of that content to recklessness with respect to the presence of that content on their service. So if you don't implement best practices, you could be exposed to liability, have your Section 230 immunity stripped, face civil lawsuits for recklessly enabling CSAM to be on your service. And that lower standard means that in addition to having the immunity stripped from you, because you didn't follow those best practices, it would make it easier for plaintiffs to win those cases, which opens up the question of, if those best practices categorically exclude offering end-to-end encryption, for example, would it be reckless, deemed reckless by a court to offer end-to-end encryption, because by its nature, end-to-end encryption means that the provider cannot see CSEM and therefore is being reckless about allowing this kind of material to be present on its service.
Riana, we have a question.
Sure.
Rishi, go ahead.
Yeah. My question's actually about a law that we haven't covered so far, which is the CCPA, the Consumer Privacy Act. And I wanted to know if, do you think that will have any implications or impact on encryption, or is there sort of potential for it to kind of stray into that area?
That's a great question. Yes, I do actually. So one of the things that I think is a problem about the Earn It bill is that it sort of sets up a direct conflict between these best practices if we foresee that they may sort of frown upon strong encryption, between the Earn It bill's best practices and governing laws such as the CCPA and other laws that mandate data security, including the use of encryption in order to protect people's data. There's this sort of what I would call like a two masters problem. So I'm trying to find the right slide that I was going to talk about here. The problem here is, you mentioned the CCPA. The CCPA refers to California's existing data security law. Half the states now have data security laws in place that say you need to protect the data that you collect and that you hold on to that is personally identifiable information, or health data under HIPAA, or there's the FTC has its own standards for sufficient data security. Otherwise, it's unfair business practice if you screw people over by not holding their data securely. So what happens if we see the Earn It Act pass and the best practices be written such that they condemn encryption and say, it's reckless to offer strong encryption, it doesn't help fight CSEM. But on the other hand, the same entities that would be wanting to preserve their Section 230 immunity are also potentially under this conflicting duty to use encryption to protect the data that they hold, in particular, especially in different sectors that are strongly regulated, such as health, such as financial data, et cetera. So that is a great question. It goes directly to this point about the sort of difference between the recognition that we really rely upon encryption to secure our data, and at the same time, this fight over recent years by law enforcement to say, but we need access to that data. What are you going to do about that? And now Congress having this this effort in place with the Earn It bill that might totally screw with that. So that's a great question. To sort of back up slightly, I've written a series of blog posts about all the problems with the Earn It Act. Some of the problems that I see are that there's just really not accountable to members of the public. There's not a lot of oversight. The membership and the way it's set up calls for having people who are experts in con law, consumer protection, or privacy, as well as experts in computer science related to cryptography, data security, or AI. But really, this is all set up to serve the whims of an attorney general who, as we know, is really anti-encryption. That or, the disjunctive or in the way this is set up, means that you could have consumer protection experts who are consumer protection experts in car seat safety or organic food labeling. They wouldn't necessarily have to know anything about privacy or constitutional law. And similarly, your CS experts might not necessarily know anything at all about what is good practices with regard to cryptography or data security. They could be AI experts who only work on computer vision or something like that. And because only 14 out of 19 commission members is needed to pass on recommended best practice to the AG for his approval, you can ignore all 4 of those experts in the law and in computer science. And because the AG both sits on the commission and would give the thumbs up or thumbs down to the best practices before they go off to Congress, there would be no point for the commission to write any best practices that the attorney general wouldn't like. So there's this problem of capture by the AG. There's lack of transparency. As far as we know, it's just going to be, if this were to pass, this commission would be a group of unelected people just passing these laws, or writing these best practices and working in secret. And it's another highly unusual move that the bill would fast track those best practices to be approved by Congress without any of the usual deliberative procedures that would normally be taken up by Congress for debating a potential bill. I talked to a Hill staffer who said they'd never seen anything like that before. There's a long history of having presidential commissions or other commissions, but the recommendations don't normally have any force. So it's weird that we would be entrusting this small number of people, not elected, not accountable, no oversight, to be making best practices that, if enacted by Congress, would then be de facto laws for privacy and security and speech on the internet. There's this obvious tension with the carve-outs in CALEA where the two of them conflict. There's problems under the First Amendment where this will lead to censorship of even legal speech, as we saw with Sesta Fosta. There's a Fourth Amendment problem that's pretty significant that could backfire and undermine the entire point of the bill, which is to protect children, because right now, entities do voluntarily scan for child sexual abuse material on their services. They do that voluntarily. They do it without warrants, and they report it, if they find it, onward to an entity called the National Center for Missing and Exploited Children, or NCMEC, which is required under federal law to receive those reports. NCMEC passes them onwards to law enforcement. Now, that mass scanning that entities do voluntarily is something that the government could not mandate directly, because if you directly scan somebody's email, somebody's cloud storage account, etc., you need to have a warrant for that if you are the government. So if this bill were to pass and come up with best practices that basically induce entities such as Apple or Facebook or whoever to scan everybody's accounts for CSAM, that would turn private companies acting voluntarily into state actors acting at the behest of the government. And then you need a warrant. And that means that all of that mass warrantless scanning, all the evidence that would come up from that risks being thrown out in court. Normally, if you don't have a warrant and somebody searches if the police search your email account, for example, they don't get a warrant for that, you can get that evidence thrown out in court in the criminal proceedings against you. So this Fourth Amendment problem might convert private entities into state actors. All that evidence gets excluded, and then what we consider to be the worst of the worst criminals committing the worst of the worst crimes then go free because the evidence against them would be thrown out of court. There's also a constitutional problem under the takings clause, which says that the government can't just take your stuff without compensation. CALEA provided funding to telco carriers for compliance because they had to re-architect their whole networks, all of their services, all of their switches and wires and so forth in order to be wiretappable. EarnIt doesn't allot a single dime for that kind of thing. So there are all of these problems with this bill. And the biggest one is the potential impact on encryption. The Attorney General currently, AG Barr, has made a lot of statements that were anti-encryption, just like the AG before him, just like various directors of the FBI have done. So we can anticipate that any best practices that he would give the thumbs up to would have to be anti-encryption. The last time he was the Attorney General in the 90s, he oversaw an illegal spying program that mass spied on Americans' phone calls. So he might also nix any best practices that that basically impeded surveillance in any way, even aside from encryption issues. So we might see this way of basically using the best practices to induce providers to keep their Section 230 immunity would require them to backdoor their encryption for law enforcement. But as said, we can't afford to do this. If you think about the Equifax data breach, any of the data breaches that have come up, encryption is one way of protecting the data that gets stored so that if it does get breached, if a laptop gets stolen out of an employee's car or whatever, it's not as much of a problem because it's all encrypted. It can't be decrypted by whoever stole it. National security depends upon this. The president uses an iPhone. So if Apple's forced to weaken iPhone encryption, that poses obvious problems for everybody who uses these off-the-shelf devices and services with some modifications in order to secure them more strongly. The fact that everybody uses the same services, the same devices, the same chat apps, etc., including members of the military, including the Senate, means that that places a lot of data at risk that does not need to be at risk because encryption is the best thing we've got for protecting data security. Even James Baker, who was the general counsel of the FBI during the San Bernardino Apple versus FBI dispute, has since left government. And he now says, look, encryption is too important. People need to just embrace reality. Law enforcement needs to embrace this reality that we live in an era of ubiquitous encryption and deal with it. And in particular, this would harm you if this bill passes. Encryption protects your ability to speak confidentially with your sources, to receive documents securely through such through secure drop instances, et cetera. There's a great op-ed that was published in TechCrunch a couple of weeks ago by Riana Pfefferkorn, who used to run newsroom security for the New York Times before she stupidly got let go for no freaking reason. That was not a good idea, New York Times, bad move there. But she has highlighted why this bill poses a risk to people like you who depend upon it, not only for you as journalists who are writing these stories, not only for your sources who want to be able to communicate, whistleblow, et cetera, securely with you, but also for readers, because most of the traffic on the web now is encrypted. So that protects against snoops being able to see and change the traffic that is passing between a server that I am trying to access when I'm trying to access a website and me when I'm reading it on my phone or on my computer. So HTTPS is an encrypted connection between, say, NewYorkTimes.com and me and my browser. So if I read a story that you've written and your news outlet uses HTTPS, I can feel certain that that information has not been tampered with, that there's nobody snooping and being able to see what it is that I'm reading. What Riana doesn't mention is, honestly, in my opinion, the New York Times series, while it, seems to have brought some daylight to an intractable problem of child sex abuse material on online services, there's some responsibility there for bringing about this bill that threatens journalism, that threatens journalists, that threatens your sources. And as I mentioned earlier, if your publication's website allows reader comments on news stories, you need Section 230, and you cannot afford to lose that yourselves either. That's what allows your news outlet to not be sued out of existence, as though that's the top thing that you have to worry about right now. So from a board perspective, passing this bill would create a lot of legal uncertainty. I mentioned earlier that it's nice that we have CALEA, and it's nice that we have these clearly set out duties around who is and who isn't bound, what they do and don't have to do. Whereas when we have this arcane, tortuous setup of the Earn It bill, where we don't know if it's going to pass. If it does pass, we don't know what those best practices are going to be. If those best practices get written, we don't know whether alternatives would be deemed reasonable in court or not, et cetera. This all impacts the decisions of investors, the decisions of boards, how they can plan for the future. I've already been hearing from investors who want to know, is this bill going to pass? How is this going to affect the companies that we're looking at investing in? We don't know how much litigation exposure would actually happen. For all of the hue and cry around SESTA FOSTA, which led to the mass censorship by providers of large swaths of content on their services, such as Craigslist taking down the entire section that it had for therapeutic services, so that a bunch of people who do massage therapy are now put out of work, or have a much harder time finding clients. There haven't actually been that many cases filed under SESTA FOSTA that took advantage of the stripping of Section 230 immunity for sex trafficking. So we don't know how much litigation would actually be faced by these companies if they were to lose their immunity. There's the two masters problem that I mentioned earlier. So we don't know how those things would interact. What happens if the best practices require a company to do one thing in order to retain Section 230 immunity, but those best practices are in conflict with other requirements under federal agencies, under state law, et cetera, to secure data? And on top of all of that, let's remember that the CEO is often a member of the board, or some top-ranking executive is often a member of the board. Who's the person who's going to certify compliance? It has to be an officer of the company. I think a lot of boards would be disturbed by the notion that one of the board members, the CEO, risks going to prison for 2 years if they certify compliance that is later found to have some problems there. So there are all of these issues, not only for journalists, not only for national security, for the whole economy, for all of us just as consumers, but also from the board perspective, this is a problem as well. Senator Wyden has introduced a bill in response to the Earn It Act that instead of going after Section 230, which Wyden co-authored in the 90s, would instead say, this is a funding and resource problem. Let's give more money to law enforcement. Let's fund preventative efforts, both at the federal level and at the state, local, and tribal level in order to try and invest in prevention. And it's a clever bill. It says, let's throw money at a problem. That got highlighted also by that New York Times story that said, look, the DOJ has not been reporting on crimes against children biannually as it's required by law to do. It's been redirecting money that had been earmarked for cybercrime to instead fight a xenophobic border war. And so this bill is a response to that. The sense that I have heard from people who have their ear bent to the hill is that there are a lot of Congress members who don't want to vote in favor of the Earn It Act because it's very unpopular publicly, because it has all of these negative consequences. But they don't want to be seen not doing something about child sex abuse. This bill gives them something that they could vote for instead. And again, like, this shows that journalism matters. The way that you report on a particular topic influences how policy responses come about. I think that New York Times series both gave us the Earn It bill, or provided some support, some ammunition for the Earn It bill, but also by reporting on the failures of the DOJ, helped give some grounds for Wyden's bill as well to come about and say, actually, let's address the shortfalls in resources and personnel and funding instead. So I know we're kind of running slow on time, and you all came here to talk about the elephant in the room, which is the fact that we're all sitting in our homes and can't go outside anymore. The Earn It bill was sort of ill-timed in that it really sort of helps underscore, now that we are all completely dependent upon Zoom and other services, that this is really just the worst time to undermine cybersecurity, to require or induce companies to weaken their encryption. We can't afford that. Everything we used to do face-to-face that required privacy, such as going to doctor's appointments, seeing your therapist, seeing a financial planner, or talking to your lawyer, all of those things have moved online. Students all have to take their classes online. If I just want to have a heart-to-heart with a friend, now it's probably going to be happening over Zoom. The very fact that we have this pandemic means that there's now a lot more information that needs to be kept private, that needs to be kept secure, that would not exist but for the pandemic. Everything from stimulus checks, unemployment benefits, small business loans, to the plethora of contact tracing apps that rely upon location information that we're now seeing crop up, to all the health information related to testing and treatment for COVID-19, as well as all of the privileged legal information that is coming about in a world of 20% unemployment, people being laid off, making insurance claims, lawsuits, bankruptcies, companies shutting down. So many of these categories of information are required by law to be protected. HIPAA protects health information. There's a federal law specifically for student privacy. And there's another law just for children's privacy online, just across the board, whether they're acting as students or not. We talked earlier about the CCPA and other state data security laws. At the same time, the government has noted that cybercrime has increased really sharply because criminals will never let a crisis go to waste. They will always come up with scams to try and exploit a tragedy that happens. And all this information that's being created, some of it has already been compromised. The Small Business Administration opened up a website for applying for economic injury disaster loans in early March. And less than 2 weeks after applications opened, the SBA website suffered a data breach that exposed the social security numbers, financial information, a lot of personal data, about 8,000 small business owners around the country. So the federal government is both calling for weakening cybersecurity, weakening encryption, and they can't even keep people's sensitive data safe for 2 weeks. The silver lining, I think, to all of this is that the fact that we're all moving online, doing all of our business online, have moved so much of our activities online, is really highlighting for the general public what the stakes are and why it would be so disastrous to pass the Earn It Act or to otherwise disincentivize improvements in computer security. It's been years that I've been working on this issue where the refrain has always been from law enforcement, oh, encryption is something that criminals use. Well, no, now we all understand that encryption is something everybody uses and that everybody needs to protect ourselves. And there's some talk about whether the techlash will just kind of go away because we all now rely on tech companies to save us. I don't know about that. I think, you know, we need to hold tech companies to account more than ever. So when they do screw up in the area of privacy and security, that helps raise public awareness to these issues. And for all of the COVID-19 focus on cybersecurity and privacy, the poster child for all of that is Zoom. The fact that we are now more dependent than ever on tech companies makes it all the more important that we be able to trust their tools that we're using. Again, as an instance of how journalism really matters, Michael Lee and Yael Grauer from The Intercept published an article that kind of created a lot of waves at the end of March, sort of early on during the pandemic, by revealing that Zoom had been making misleading claims about their video calls being end-to-end encrypted. Remember, I said that when something is end-to-end encrypted, that means that only you and the person you're talking to can read or hear or see the decrypted text or audio or video of that call. The way that Zoom was using that term was misleading. What they were talking about was encryption of the connection between Zoom's server and you using their app or looking at it in your browser. That's not the same thing. Zoom still had the ability to access unencrypted video and audio. On top of those misleading claims about end-to-end encryption, they also had just been pretty sloppy about privacy and security. For the last several years, they were notoriously slow to respond to bug reports. I have a list here of some of the problems that have been publicized since the lockdown started happening. These have now been fixed, but these are the kinds of problems that resulted in a lot of fallout for the company. Some entities had placed bans on their use, such as all New York City schools, who I think just a week ago lifted the ban on using Zoom for instruction. Different companies have said this isn't secure enough for our business purposes, for all of our confidential business information. Employees aren't allowed to use Zoom anymore. We're going to use something else. They've been sued by shareholders for making misleading statements when they had their IPO last year about the security of their services. Several state AGs have been investigating them. They just finally resolved the investigation by the New York State AG a couple of days ago. And multiple senators have been calling on the FTC, which, as I mentioned, polices unfair data security practices to go after Zoom. Ironically, one of the sponsors of the Earn It bill, Senator Blumenthal, is one of those people who has been calling on investigations and has asked Zoom to account for why it was making claims about end-to-end encryption and to account for its privacy problems, even though it's widely known that his bill would probably result in disincentives and forcing companies to abandon end-to-end encryption. And even though when people sort of raised the problems that I mentioned with the Fourth Amendment and mass warrantless scanning about his bill, his response was to circulate a document on the Hill that said, look, Americans don't have any right to privacy online anyway. That's literally what he said, and yet here he is now out here pretending to be concerned. It's disgusting if you ask me. But the good thing about all of this attention that's been paid, again, thanks to journalists investigating these stories. You know, I talked to Yael about her story in The Intercept. They worked on it for months. Being able to bring out these kinds of stories has led to reform. Zoom has really tried to up its game when it comes to privacy and security. They dropped that misleading claim about being end-to-end encrypted. They paused all features that weren't related to privacy and security and are in the middle of a 90-day sprint to try and fix and improve their privacy and security issues. They are fixing and responding to bugs much faster than they used to be. They've added a lot of security features, such as the waiting rooms that we've all been waiting in to get into various sessions of today's events, better defaults. And they've hired a bunch of outside security experts, including former chief information security officers from other companies, such as my colleague at Stanford, Alex Stamos, who has been really, I think, helpful in helping them go from what was originally an enterprise software product, basically, that was used by mostly companies, which had, you know, backstops of HR policies and so forth, to suddenly being used by everybody for everything all the time. They were really sort of caught flat-footed by that. So very quickly, before I finish up, I wanted to share this video conferencing guide with you. Martin Shelton at Freedom of the Press, who is an expert in security for journalists, has put this together and has been updating it periodically. to sort of show if you are a journalist and you need to do video conferencing, whether that's with other members of your newsroom, whether that's talking to sources or interviewing somebody, there might be different options that you might need at different times for different purposes. And you might be thinking about issues such as, does this support end-to-end encryption? Or can we self-host this so that it doesn't have to go through Zoom server? We can put it on our own server and nothing gets sent out to Zoom. Can you register without having an account if you want to make sure that you have sources who don't have to give up their email address, et cetera, in order to join a call with you? And then, you know, how many people can be on that call? So these are all some options. I'm going to be circulating this slide deck. I'll send it to Kristen to share with all of you after this, or if you just Google, you can find the Freedom of the Press video conferencing tool guide.